Good afternoon and welcome to a new edition of the GeoTech Hour, in which we explore the intersection of data privacy, tech standardization, and geopolitics. My name is Julian Müller-Kalla. I serve as a resident senior fellow at the GeoTech Center, which tries to serve as a bridge between technologists and policy experts and policymakers. We try to bring together experts, thought leaders, decision makers to evaluate and discuss the implications of emerging technologies on society, politics, and international relations. Today, we, as I said, talk about standardization and China, obviously, but I want to start us off with talking about the GDPR and its impact on geopolitics. Other countries have started to adopt similar privacy regulations. They've often seen it as a model, and the US, and the European Union and the European Commission most certainly sees itself as a standardization player and frontier regulator of emerging technologies. A similar trend is obvious in standardization practices, particularly when China put out its China Standards 2035 plan, which outlines a strategy to influence global standards, setting technology over the next 15 years. Critics obviously have pointed out that it might be an attempt to dominate global tech markets and replace the United States' leading position in that. I am incredibly delighted that I am joined by three distinguished experts, namely Ashish Agarwal, who serves as an advisor to the American Edge Project, Pam Dixon, who is the founder and executive director of the World Privacy Forum, as well as Jane Kin, who is a professor of law at the University of Washington. So thank you so much for taking the time today. And I want to start off with Ashish. The two leading questions of today's GeoTech Hour are pretty much, how might increased Chinese involvement in standardization affect data privacy elsewhere around the world? And second, how can American actors in standardization bodies advocate for strong data protection? So the floor is yours.
Well, Julian, first of all, thank you so much for moderating this discussion, and to the Atlantic Council for hosting it. It's a very important and timely topic, as we've seen from events around the world today. My name is Ashish Agarwal. I'm an alumnus of the U.S. Federal Trade Commission, Department of Justice, and elsewhere. So I've certainly worked on these issues, in and out of government. I wanted to make just three brief points to kick off the discussion. Number one, it is imperative that the United States and the Western democracies work together in standard setting and privacy issues. While the United States and Europe don't see eye to eye on everything, we broadly share the same beliefs in individual privacy and liberty and free markets, and we need to coordinate together across the Atlantic and the Pacific, encountering what really is a new axis of China and Moscow and other autocratic countries that don't share those same values. Number two, I think it's very important that we collectively support and allow our leading technology companies to continue to operate in the ecosystem so that they can both continue to develop their technologies and allow commerce to function. The transatlantic data flows alone account for something like $7 trillion worth of commerce. And unfortunately, there are moves, both in the United States, led by some progressive impulses, and in Europe, led by some protectionist impulses, to try to curtail the ability of those companies to operate. And I don't think any of us want to see a world in which the leading technology companies, the most advanced companies in fields like facial recognition, AI, others are based in China. That would give them much more ability to try to influence the standard setting process. Thirdly, and finally, there are very concrete things that the United States and Europe can do to try to advance a more open and inclusive model for internet regulation. In particular, there is later this year an election to the United Nations for the Secretary General of the International Telecommunications Union, which is a part of the United Nations, which oversees a lot of global the global regulatory framework, there's an American candidate and a Russian candidate, and it's important that we collectively support the American candidate so we can continue to have free flows of data while protecting privacy. Thank you.
Thank you very much, Ashish. A lot to pick up on, and I'll certainly get back to those points that you've used in your introductory statement. But I first want to turn over to Pam Dixon and introduce her. Yeah, please, the stage is yours.
Thank you so much, and thank you for your invitation to participate in this discussion. I appreciate it. It's really timely and important. So I just have a couple of brief points to make, and then, of course, I look forward to the discussion. The first is this. You know, China has been setting standards for a very, very long time. I mean, the very first records, I believe they're one of the first standard-setting jurisdictions going back to 200 BC setting standards. So this topic is not new. It's going to be recurring throughout our lifetimes and those of others. So I think the important thing here is to look at some of the new issues and how they'll be adjudicated. So if you look at what I would call the standards ecosystem, it's quite complex. There's bilateral agreements, there's multilateral agreements that seek to have a standard that's harmonized across multiple jurisdictions by, for example, the UN or another entity. And then you have, of course, unilateral standards that are developed within country. And then there's all sorts of sectoral standards cross-sectioning that. So this is a very, very, very complex ecosystem of activity. And it's really important to remember that and figure out where everything is within that total ecosystem. And I just wanted to bring one point forward because it really is an ecosystem. And I wanted to talk about two contrasting kind of issues. One would be, for example, the 2020 EU-China Agenda for Strategic Cooperation. And there's a link to that the council will drop into the chat for the audience. In this, there are a lot of agreements as to how China and the EU will cooperate on issues. And there's a lot of discussion about, for example, safety regulation. And in general, if you look at China and Europe in terms of their toxic chemical safety regulations, they're pretty harmonized. It's not complete, but there is harmonization there. That's a good thing. But now there's a new issue to consider, which is this. AI, artificial intelligence and machine learning, is really the very next very substantive issue that all jurisdictions are going to have to deal with in terms of competitive and cooperative agreements. And this is where you see a lot of shots being fired across the bow. That's a terrible metaphor. This is where you see a lot of activity. So for example, in the European Union, you see the AI Act, it's a proposal. In the United States, you see a variety of standard setting efforts getting started. But the bottom line is that the area of AI and data governance, not so much data privacy, but data governance, I think that's where you're going to really see the next activities take place. I'll wait for the discussion to talk more about how people who are interested in data governance and privacy and AI issues can get more involved in standard settings. But for now, I do think that that's where a lot of activity will be taking place. Thanks.
Thank you so much, Pam. And Jane, over to you. I maybe want to add one layer to the questions that I've outlined in the beginning. Talking about the power and example of the GDPR and the ability of the European Union to position itself as a regulatory superpower. Do you see that being the case? And is that potentially a model that the Chinese are trying to follow when it comes to this? So please, over to you. And you're muted.
Hi, Julian. Yeah, thanks so much for inviting me to participate in this discussion. So when we were doing the technology check earlier, you said that you enjoy a particularly vigorous debate. So I'm going to take you up on that. And am going to suggest that the GDPR does not establish Europe as a regulatory superpower, that the GDPR is actually profoundly misguided in much the same way that prohibition in America was misguided in the 1920s and had to be repealed. I think the GDPR is creating barriers to Europe's global competitiveness in the coming competition based on decision-making and the development of knowledge. So my position on the GDPR is probably going to be quite different than that of most people participating in this discussion. In the United States, the Uniform Law Commission recently finalized a draft called the Uniform Personal Data Protection Act, which creates a framework within which a responsible balancing of costs and benefits can take place so that artificial barriers to knowledge creation are not created. And in order to provide the concreteness that organizations need for compliance efforts, there's a system to permit ANSI accredited standards organizations, voluntary consensus standards that meet the ANSI accredited standards due process guidelines, to be quote unquote recognized by regulators as a sort of safe harbor. Now, because you said your subject was international relations, so I don't know if you know that that was actually the approach to building the single market that the European Union took in the 1980s with the New Approach Directive. So that was for industrial standards. So there could have been a situation like that. The GDPR has hand waves towards industry standards, but to the best of my knowledge, there aren't any emerging. So what I would suggest is that the GDPR is a blind alley, and the sooner the politicians in Europe figure that out, the better it will be for the health of the European economy. I think that one of the fun things, so I first went to China in 1984, and I visited China regularly since then. And a kind of fun parlor game you can play is, in what ways are China and the United States similar, and in what ways are they different? And one of the things that combines China and the United States is a profound commitment to pragmatism. And I know that in international relations, there's been a lot of questions raised about what will come with the end of the unipolar moment that in international relations that was created with the failure of the Soviet Union. And I think the GDPR represents that kind of unipolar thinking. And we're moving towards a more multipolar approach to issues, and what matters is outcomes. So when you look in the knowledge governance, information governance field, the most widely adopted standards are based on ISO 9000. So it's a plan, do, check, act management system in which you're continually measuring outcomes against your stated objectives. So we have a good model for information privacy standards, the flexible adaptive system standards. So I think that what China is doing is completely compatible with that. So I actually think that China's commitment to emerging as a global leader in standard setting, taken in combination with the overall pragmatism of Chinese government policy in terms of advancing China's interest and in terms of inclusion for the Global South through its Belt and Road Initiative, it's hard for me not to see China's standards 2035 initiative as a positive development.
Well, I'm sure that Ashish has a lot to say about this, but I want to first have one follow-up question. So when you criticize the GDPR, and I've heard similar criticisms here in Europe as well, that it basically prohibits the comprehensive collection of data that obviously is necessary to train AI algorithms. What's the alternative?
Oh, I wasn't making that point at all.
Okay.
So I don't base my criticism on that. So I think it's very common when people start studying technology to conflate technology with change. So technology is never more than a tool. AI is just a tool. It works for certain things and not other things. And so training AI data sets, that's a particular process, and making a decision to lean into that or to refrain from that has certain costs and benefits, and policymakers can choose that. What I think is the bigger problem is if we think of the continuous improvement process that's embodied in it's embodied in federal legislation like FISMA, the Federal Information Security Management Act. It's embodied in other continuous improvement standards. For that, there has to be the freedom to develop new ways of generating and measuring data. So I think the problem with the GDPR is it's like taking in copyright law. Copyright is the author's right to protect their creation. And in US copyright law, we have a defense called fair use. And so the logical fallacy of trying to protect personal privacy as an independent freestanding right is like trying to convert fair use into an independent freestanding right. Because what ultimately empowers people is the capacity to make better quality decisions. And I think commitment to a very specific form of data protection is what's creating barriers to the development of knowledge governance in Europe in a way that's globally competitive.
Thank you very much for that, Jane. Ashish, your reaction to, should we welcome China's ambition to set global standards as a global actor, or is that a dangerous trend?
Yes, it is a dangerous trend. But let me start out by talking about the GDPR briefly, and then I'll move to China. So I'm a little less critical of the GDPR. I think that I actually give the Europeans credit for getting out in front of the issue, and I think it spotlights the need for the United States Congress to pass a comprehensive privacy law rather than the patchwork of state regulation that we have now. I think it's a real barrier to the growth of commerce, and until the United States and Europe are able to sort out issues with the data privacy shield, I think that is going to hamper the development of new technologies on both sides of the Atlantic. Having said that, I also agree with Professor Nguyen that the Uniform Law Commission recommendations, which he referenced, are a better and more balanced approach to both protecting privacy and allowing commerce to proceed. We shouldn't. It's easy to take for granted all of the many wonderful technologies that we have that are available at no monetary cost to consumers. Your social media sites, your mapping services, etc. But there are companies that through the ad-supported revenue model do use the data from users to enable those services to operate effectively and also to make money off of them. They're businesses after all. And we shouldn't go so far, in my view, as the GDPR to cut off the ability of those companies to operate. So to that extent, I do agree with Professor Nguyen. Now, on China, I would very much push back on the notion that we want more Chinese involvement in standard setting organizations. I guess I would agree that the Chinese Communist Party is pragmatic to the extent that they're always pursuing the interests of the party. But we've seen just what's going on in the world today in the Ukraine. The Chinese state media, TikTok, on which, by the way, the Chinese government now holds a board seat in ByteDance, which operates TikTok. They are very much working hand in glove with the Russian government to cut off information flows that the brave Ukrainian people are trying to get out. The Chinese are also using standard setting organizations to try to further the interests of Chinese-based companies. The fact that Chinese nationals, people with close ties to the party have been heavily involved in these organizations, including the current head of the ITU, gives them credibility, gives their companies a little more of an advantage in developing kind of the next generation of technology. And I would hope that both the United States and Europe would want to very much push back on that model. Our model is one that allows for the free flow of information. And if we don't, if we don't push aggressively for that, I think what you'll see is a move towards an internet in which individual governments are more able to control the flow of information and flow of data. And I don't think that's something that is consistent with Western values. I don't think that's something that's in the interest of the United States.
So Ashish, when you say it should be countered, there should be an international democracy alliance to push against those developments. China represents around 17% of the global economy. So global standards can develop when the US, Europe, Japan, South Korea, Israel, Australia, other countries come together and agree on certain standards. But often the problem is that what are those standards? The United States itself doesn't have a national privacy law. So are we just punching significantly underweight in terms of the basic question is being anti-China enough to set an answer to this, or should the position itself be strengthened with national laws and agreements on the Western side?
So yes, as to that question, I would say that it is incumbent upon as I said, Congress to enact a national data privacy law, which would better position the United States to speak with Japan, Israel, what Western Europe, and developing what those standards are. And let me clarify: I would not suggest that China should be excluded from these standard-setting organizations. Obviously, it's an enormous country that has grown significantly over the past few decades, and they have their interests to pursue, and that's fine. But when we're talking about who are the who's going to be preeminent in setting those standards, I would suggest respectfully that it should be the people who share American and Western European values. And concretely, there is an election later this year to head the ITU, and I think it would be certainly in all of our collective interests to have the winner of that election be an American. I give the Biden administration a lot of credit for pushing that candidate. Her name is Doreen Bogdan-Martin. Versus the Russian candidate who is also a former executive of Huawei, who probably doesn't share our values.
Pam, you wanted to react to this?
Yes, there's just so much to say. So I'm going to start with the GDPR. So let's be very careful as we talk about the GDPR. We have to understand that now the GDPR has aged. We now have results in, I'm just going to talk about the data. The data is that the GDPR is not really being very well enforced. And this is a really significant problem. And the Europeans have already begun to recognize this. I do believe this is part of the impetus for the EU AI Act. To kind of have a bit of a redo in the area of, for example, biometrics and artificial intelligence and machine learning, because there's a significant recognition that there are aspects of the GDPR which did not address this in a way that allows Europe to be competitive. To echo what Jane said, she is saying the right thing. There are not good factual arguments against what she said, against her position. So just so you know, the facts are on her side. I wanted to bring in, though, the idea of data protection regulation and how it relates to standards and standardization. So I'm going to move it a little bit away from data protection and move it more toward data governance, because it's a more comprehensive idea. So when you're really talking about data governance and all the different regulatory structures that provide data governance across various jurisdictions, the US does have a sectoral data governance system, and it's robust. It's not like Europe's system, but it is still robust in its own way. We've got the Fair Credit Reporting Act in the financial sector, among other regulations. We've got HIPAA in the healthcare sector, or the health sector, amidst other regulations. And I could go on and on. But the most important thing to think about is this. If we use this as a yardstick, then the US has already lost. China has already passed very, very robust legislation that mirrors much of GDPR. So this cannot be the measure of what we're saying here. If so, the US has already lost. And we could definitely discuss that because, again, we're just dealing with facts on the books here. I think there's another way of thinking about this, which is we really need to think in terms of systems. You know, the national standards organizations, and there are at least 500 of them that I have looked at. There are likely more now. But the issue is that these standards development organizations, some are quite large, like ANSI, like ISO, some are smaller, some are national, some are multinational, and so forth. But this is an ecosystem, and we can't really think just bilaterally about this ecosystem. We've got to think, okay, it's not US versus China. It's not China versus US. You know, neither China nor Europe nor the US can just simply change a standard unilaterally. There has to be notification made to WTO. It's required in the charter. It's mandatory. And all the other signatories get a chance to come in and make comments. So really, what we're talking about is an interconnected web already. So that changes the conversation. For me, the question is this: okay, what are our interests going forward? I don't think that we can renegotiate GDPR, but what is directly in front of us is the question about AI and machine learning, which is very much on the table. And how are we going to navigate this? So again, we have the EU, which has proposed the EU AI Act, which I am going to, right now, my thinking is that very few jurisdictions will sign on to this because most jurisdictions look at AI as a race, and they're in the race already, and they want to win and get to that finish line first. They don't want any legislation in their way. So I think that, your earlier question, is Europe going to continue to be, a regulatory superpower? I think that baton may have passed with the GDPR. I really do. And so we will have to wait and see what happens. Things can change. But in terms of, the geopolitical situations and whatnot, I believe that the very complex ecosystem that is the standards ecosystem is resilient against some of the geopolitical issues that we're seeing. And there's redundancies and resiliencies built in. But I do want to mention one thing, and I'll be quick. You mentioned privacy groups and privacy interests and standards. So across the board, so when the Uniform Law Commission decided to add voluntary consensus standards to begin to set standards in the US at the state level in privacy, I was overjoyed. I was like, this is great. This is how we can start getting standards in privacy that are fairly adjudicated, properly adjudicated according to, pardon me, but OMB A119, which is what controls it in the United States. And, it's really been rejected by the privacy advocates. They're like, voluntary consensus standards, it's self-regulation. We don't like it. It's not self-regulation, but it's been very, very difficult to persuade advocates that standard settings is what we want in privacy. We want to be able to have people with pro-privacy viewpoints sitting at the table setting these standards. But there's been a great reluctance to do so thus far. So I think that we've got to look at that and wonder what's happening. Thank you.
Well, we definitely need to get back to this, especially also about sort of the bifurcation that we're seeing. I mean, you're describing in an ideal world, but we're seeing the exact opposite of what is happening so far in terms of, a splinter net and different systems in which other countries have to choose. But Jane, I know that you wanted to come in, so I wanted to give you the chance, please.
Oh, thank you very much. I was going to say, yes, we've all been, those of us who participated in drafting the uniform law that allows voluntary consensus standards to be quote unquote recognized by enforcement authorities as anti-privacy. It reminds me of a quote by a political science professor at Harvard, whom we presume is of German origin. His name was Karl Deutsch. And he said, power means being able to afford not to learn. And the privacy advocates in the United States have been unwilling to learn what voluntary consensus standards are. And so they vilify them on completely spurious grounds. I was going to say that Ashish's idea that the United States needs a federal statute in order to have a coherent legal framework. There's another old saying from technology, which is it's not a bug, it's a feature. So the current framework of information governance laws in the United States, in sociology, we would say it's an institutional isomorph for American society. The closer the congruence between the structure of a law and the structure of existing institutions and practices, the greater the rate of compliance, the less the cost of compliance. And the American system actually is remarkably resilient. It's risk-based. So if we were to migrate in information governance towards plan, do, check, act, continuous improvement models, the result is risk-based regulation. The Americans have been there for 40 years. So the American system actually works very well. Ashish said he was formerly with the Federal Trade Commission. There's been, oh golly, I used to keep count, maybe 100 consent decrees. The FTC enters into enforcement agreements for violations of its Section 5 authority over unfair and deceptive trade practices. It's a de facto information privacy regulator in the US. If you look at every single one of those enforcement decrees over the last 20 years, what the organizations are required to commit to is to implement plan, do, check, act, subject to the audit of an independent third party. So we do actually have plan, do, check, act information governance laws in the United States. And what the uniform law does is it permits that to be generalized out at the state level. So if we think that the end game is appropriate risk management and the capacity to create value for users and to integrate seamlessly appropriate risk management is a way to talk about the quality of decision making. That's why the ISO 9000 based standards like ISO 27000 and some other ones, ISO 27700, they take that process, which is organizations have to become aware of what they're doing. They have to develop explicit goals. They have to develop key performance indicators of their progress towards those goals. They have to measure and evaluate. And when they discover that something's out of compliance, they need to adjust. So if we compare that with, as my colleague Pam Dixon quite rightly pointed out, the invocation of abstract fundamental rights rhetoric in Europe, combined with widespread non-compliance on the ground, I think that the American pragmatic system is clearly superior in terms of the actual rate of information privacy protection it delivers American consumers. And globally, almost all consumers of new information economy products have benefited from America's status as the global innovator. The number one search engine in Europe is Google. The number one online merchant in Europe is Amazon. So the Europeans, just like they piggyback on American military defense until maybe 6 weeks ago, they've been piggybacking on American innovation based on American pragmatism. So that's why Europeans need to be worried about the atrophy of Europe's capacity to innovate in a global economy where competition is based on the quality of knowledge governance.
Ashish, do you want to react to this?
I do. Professor Nguyen, I might not agree with every single thing that you said on this panel, but I love that you're on this panel, and I agree with so much of what you're saying. Three quick points. One is Professor Nguyen is absolutely right to raise the issue of compliance costs. We talk about privacy, sort of in the abstract, with the thought that, oh, all these companies should be doing these things. But let's recognize this goes back to, I think, maybe to our initial point about the GDPR, which is that imposes real costs on companies, especially your smaller companies that don't have huge legal regulatory compliance teams that are able to ensure that a company's not going to be fined tens of millions of dollars or euros. And so whenever we're talking about a privacy regime, we have to keep in mind this imposes real costs on the private sector. Second, Professor Nguyen mentioned the FTC and some of the very good work the FTC has been doing in the space in terms of privacy protections. A problem with that, though, is that it's not obvious to businesses what they have to do to be compliant with the law. You can have a company, and you have had companies that have invested heavily in cybersecurity, for example, are still subject to a cyber attack. Nothing's foolproof, of course, and are still then subsequently hit with a big fine from the FTC. So that's why some sort of national standards, I do think would be very helpful for companies, and could also account for the fact that your smaller companies aren't going to have the resources of your big tech companies, at least up front, in order to offer the same sorts of protections for consumers. The third point I would make is that let's not forget that the market is adjusting to take into account consumers' concerns for privacy. You can turn on the television now and see advertisements from this alternate search engine called DuckDuckGo, and part of their business is different protections for privacy than offered by say a Google. They don't capture as much data, and so to the extent that consumers are concerned about privacy, they want to protect more of their data. You're seeing companies pop up that are more that are very much paying attention to those sorts of concerns. And you're also seeing, and this is one of the Q&A questions, you're seeing even the big tech companies start to pay more attention to consumer privacy, like Google, Apple, Facebook, and others.
Yeah, I definitely also want to get to the Q&A questions, because there are a couple of really interesting ones. I just a few, but Pam, you wanted to react as well.
Yes, actually, I want to answer 3 of the questions that attendees asked, and it's in response as well to the dialogue. So I want to talk about the role of companies in standards. And basically, I want to talk about the role of stakeholders in standard setting. The really great thing about voluntary consensus standards with standards development organizations is that there are rules of the road and they're agreed upon globally. This is really articulated in the ANSI Essential Guidelines. It's articulated in the WTO, and in the US in particular, it is very clearly articulated in OMB A119 circular. And the requirements for all stakeholders are equal. That means individuals, it means civil society, it means companies, everyone, all stakeholders get the same rules. It must be fair, it must be democratic, there has to be a form of consensus, which is deeply defined and has been very polished over the years. Everyone has to have information, there's redress, there's a lot of real requirements for standards development organizations. It's not this free-for-all, it's not ad hoc, it is steady. And if you do not meet those requirements, the standard will not be a go. So it's really important to understand that there are clear, very firm standards in this area. Second thing I would point out, and so, it's not like China has its own rules and there's all these different rules. No, there's one set of rules really globally for how these standards are set up. And the rules, by the way, are designed to avoid anti-competitive behavior, dominance by any particular market player, et cetera. So the role of companies is really tamped it down, and all the stakeholders in the process, including all of you and all of us, you really have a good shot at making a big difference in a standards development process because of these rules. So that's a good thing. So there's no one company that's dominating standards because of these rules. That's very important to understand. So someone asked about interoperability and AI. It's not so much the hardware and software that's going to be traded across borders. What we're already seeing are prefabricated AI codes and systems being traded. I mean, AI packages of, and it's even can be done in the cloud. You can upload your data to the cloud, get an analysis in an hour and pull it down. This is more of how things are going to be moving in the future, and this does require cross-border agreements. And then thirdly, someone pointed out that China's use of AI, for example, can be less than what we in the US would like. So for example, a very, very unhappy use of face recognition systems and monitoring of individuals and whatnot. So this is where we have to stop and do something that's very difficult to do, which is this. There are technical standards and technical operating standards, and then there are political uses and uses of the data. We can mitigate for all sorts of privacy and human rights and all sorts of things when we're building standards. The one thing there is not mitigation for is politics. When China decides to use a standard and they put it to use in a way that we don't like, that use can be political. This is out of the realm of standardization and into the realm of politics. We see this all the time with, for example, face recognition and biometric technologies, especially identity ecosystems. You can have the most beautiful identity ecosystem in the world, built to perfect technical specifications, totally fair. Maybe it doesn't even have biometrics in it. But if you use that system in a negative way, and in a political way, for example, in Kenya, there are certain ethnicities that are excluded by the government from getting a formal government ID. That is not a technical problem. That is a political problem. So we have to disambiguate these particular problems. I hope that's helpful, because this is one of the understandings that I think crops up in some of these discussions. Thank you.
I think that is an excellent point, because a lot of the discussion that we see is obviously motivated by politics, and particularly when it comes to the great power competition narrative. I obviously share the concern that Ashish mentions, when we know none of us wants to live in an Orwellian state where social credit scores are determining whether we can travel or not. But if that's the goal, what are the means to achieve that goal? And Ashish, I want to turn to you. Is the democracy argument a leverage to ultimately come to a compromise, or is it a precondition for any sort of engagement? And the reason I'm asking this is you've worked in administration that was responsible for a sort of disengagement, leaving the TPP, the economic framework for South Asia doesn't include China. So it's very much, sort of anti-China, with the democracy argument that you yourself have made in the beginning. So is that building leverage for further negotiation, or is that a precondition for engagement at all?
I think it's about building leverage. I mean, we cannot, just as we all share the same planet, and I don't think we can take our ball and go home and ignore the fact that, as you say, China is 17% of the global economy. I do give the Trump administration a lot of credit for putting a spotlight on China and raising the issues to a national level in a way that I think now has bipartisan support of the United States, and even probably even across the globe as well. A lot of concern about the autocracies, and certainly Ukraine puts a spotlight on that. But I think the leverage that we, the West, have really comes in large part from our values that continue to appeal to people throughout the globe, whether you're talking about those poor folks in Kenya who aren't able to get IDs. That certainly strikes a Western ear as just bizarre and fundamentally wrong. But the ideals of individual liberty and freedom resonate with everybody. And the other huge leverage that we have is our technology companies. The fact that we're even in this great power competition is in large part due to the fact that the world's leading technology companies are still largely American companies, and we certainly certainly a number of European companies in there as well. But they're the ones who have products that are attractive to consumers, and the fact that they are able to be part of these standard setting organizations and give them direction and guidance as to what is going to allow them to operate and satisfy consumer demand is a huge selling point, gives us an enormous amount of soft power. And from a policy standpoint, I think it's critical that we not inhibit their ability to satisfy that consumer demand.
Thank you very much. Jane, a question both to you and Pam. So, I have the experience from coming from Europe, and the discussion around national ID laws, something like that is always very striking. Here, nobody has a problem that you have a national ID, that information are being collected where you travel from the government. Everybody is sort of rather suspicious when it comes to data collection from private companies, which is ultimately reflected in the GDPR. In the US, the picture is very, very different. The reason you never had a national ID is because everybody is afraid of authoritarian governance control. But banks have a lot of information about you when you use your credit card, when you apply for mortgages. How do you square the circle in the sense of combining those difference in attitudes? And I imagine that the Chinese have their own morals and views. Is there even a possibility of a global governance of data collection?
Okay, so first of all, absolutely yes, there is a possibility of global data governance. And in order to get from here to there, the West has to overcome some of its own blind spots. So by profession, I teach in an American university, and I am a member of the bar. And I've been studying basically continuous improvement standards for more than 20 years. And the two black holes in American society for implementing continuous improvement are higher education and the law. So in medicine in the United States, we have the Medicare, Medicaid programs are driving outcome-based compensation. So the medical profession is long overdue for evidence-based practice, which is what they call it. But there hasn't been any corresponding equivalent move in the United States. So there's a student debt burden, and progressives in the United States talk about forgiving student debt instead of requiring faculty members to measure outcomes and find ways to achieve better outcomes for less, which is what you get with continuous improvement. The Black Lives Matter movement pointed out that the American legal system is failing to meet the needs of more than half of the Americans, members of American society. In courts in the United States, in family law matters, more than 90% of the people in court have no lawyer because they can't afford one. So we have a crisis of access to justice in the United States. And the American Bar Association president said that the solution is for the federal government to subsidize legal education. It's like, no, the solution is for American education to become more responsive and more dynamic and more effective. So we need to internalize the values of continuous improvement in the institutions in American society that generate knowledge. And then, because the end game is the standardization of knowledge governance. And what the Chinese have shown is in their quest to restore their status as a leading nation since their century of humiliation and their suffering at the hands of Western imperialists, that's where their pragmatism shows. So in 2017, Ke Jie was the world's best player of Go. and he was defeated on Chinese television by the AlphaGo artificial intelligence system. 3 months later, the Chinese Communist Party announced that China was going to be a world leader in artificial intelligence by 2030. It's like, that's a useful technology. So it's when you look at innovation, these kinds of innovations have the capacity to release, human productivity and allow people to fulfill their potential. And it's like, we need to focus on the realization of human potential that's possible, and then look for ways to mitigate the risks that can be internalized in a cost-effective way, rather than starting out with risk mitigation and prohibition on things. So I think there absolutely is. And in order for the United States to keep up with China, it's not about subsidizing standard setting. It's not about subsidizing individual companies. It's not about antitrust policy towards tech companies. It's about looking at the fundamental engines of knowledge creation in American society and how they've been cartelized and they need to be deregulated.
Pam, there was a lot of head nodding. Anything that you would want to add?
Yes, I'm sorry. I was just listening and thinking, what really came to mind as Jane was talking is that, something we haven't really talked about yet is that standards do create markets. You just can't avoid that. If you look at the literature of when standards were created and then what happened in the market after, like, an important standard like Bluetooth is created. I mean, if you think back to the Bluetooth standard, okay, it was difficult getting that standard together. But once that standard was determined, Bluetooth has taken off. I mean, I have an array of Bluetooth connections. I mean, I've got a Bluetooth mouse, I've got a Bluetooth keyboard. We all have a lot of Bluetooth in our lives. I think it's really important to take a look at the way standards and the standards ecosystem can create markets and think, okay, if standards like Bluetooth can create markets for Bluetooth products, what could standards in information and knowledge governance create? We don't have those standards yet. That's what personally I'm very interested in seeing with voluntary consensus standards. And what if we had such standards? What if it was bilateral or multilateral standards in the area of knowledge governance? I could see AI standards being done this way. Could we have a standard for how AI is used in certain settings, for example, in health diagnostics, and so on and so forth? I think that we're kind of missing opportunities here already by not looking at this issue of, okay, here's the data, here's the information, how can we set a governance standard here? And we're just not seeing it yet. I hope we do, though. I think it's very important. And, another thing I would say about a lot of the privacy law that's being proposed today is that it's very, very general and built on very general principles. And this is fine. But if you're a company or even a small NGO and you're trying to implement these pieces of regulation, at some point, the rubber meets the road and you're sitting there going, okay, what do I actually do? So we've got to remember that practical part of things and understand that we have to address it. We can't just have these really big, poetic, beautiful thoughts and then leave off the rest of the work. We've got to start at A and go all the way through and really finish things off with practical guidelines that are fair. Otherwise, they become unfair. And this is where you get into problems. Thank you.
Jane, a very brief reaction to this because you have your hand up, but I want to get to one question in the audience and Ashish. So just a quick reaction, please.
Okay. Are you familiar with the work of Gerd Gigerenzer? He's a German economist. So he works in the same field as Tversky and Kahneman on cognitive bias. And he suggests that effective problem solving depends on fast and frugal heuristics. So he's criticized Tversky and Kahneman. And so here's a fast and frugal heuristic for how the West can compete with China. No regulator should regulate any process or technology that they haven't themselves implemented. So an example of this is in the Payment Systems Directive 2, the Commission regulated the use of application programming interfaces by financial institutions in Europe. It's been a complete train wreck. Okay, so the Commission of the European Union should publish an application programming interface through which it receives data and shares data with regulated entities. Once they've got it up and running for themselves, they can responsibly regulate it. So if regulators hold themselves to the same standards that they hold the industries they regulate, the gap in the understanding of what technology can and cannot do would be narrowed.
Thank you, Jane. So Fritz Terrell Frantz asks in the chat, and I'm going to end with this question because we're running out of time, whether there are any thoughts with regards to the standard setting hearing tomorrow in Congress. And I want to combine this thought, Ashish, to you with what does the US Standards 2035 strategy ought to look like in the competition with China?
Well, let me just say that, there is, in terms of tomorrow's hearing, there is actually a fair amount of convergence, across the aisle in terms of standard setting in the United States. So NIST, the Patent and Trademark Office, DOJ recently released, new guidance for standard setting organizations, how they should operate and under what circumstances those are going to create, antitrust concerns. So there's actually quite a bit of harmony between the guidance released by the Biden administration and the Trump administration and the prior guidance, and I think that's a good thing that will only, strengthen the ability of the United States to have, a more consistent voice, overseas. I briefly did want to talk about the point that Professor Wynn made about the drivers of technology growth overall, and she's absolutely right about the importance of knowledge and education. Of course, I would respectfully also say that there have been a lot of studies as to analysis as to why is it that the world's leading technology companies, Google, Facebook, Amazon, Apple, were created and grown in the United States rather than Europe. And I would respectfully suggest, and it comes back to a point I made up top, that at least some of the explanation, I think, comes from the legal and regulatory framework that we have in the United States that rewards success and innovation. We don't have these sorts of abuse of dominance laws that Europe has, and it comes from we don't have a GDPR, so it's easier for companies to use data and capitalize on it and analyze it to create products that consumers want. So I think there's fortunately a lot of harmony between the United States and Europe in the democracies in the Pacific, and I think we should only seek to expand upon those relationships.
I appreciate it. So I'm not going to push back as a moderator on the abusive laws of the European Union, but I think your point is very well taken in terms of, I think for a really, really long time, and that was true for the last Cold War, at least, is that the source of American power abroad has always been the strengths of its democracy at home. And if we talk about, who's going to win the 21st century, when it comes to technological competition or political competition, I think the best cases are always to be made for creating a system that other desire and instead of opposing alternatives. With that, I want to thank you so very much for joining us today. This was a very fantastic and fascinating conversation. Ash, Ashish, Pam, Jane, thank you so much for taking the time. And thank you to all of you for joining us on this GeoTech Hour. If you're interested in these kind of conversations, follow us on Twitter at AC GeoTech or check out our website. We have done some standards reporting as well. Julia Neer, who has helped put together this event, was the lead author on a Standardizing the Future report that we published last year, as well as other interesting articles. And I hope everyone has a safe and a good day. Thank you so much.
Thank you.